Every U.S. immigration story begins with one of three ingredients: love, talent, or money. But what happens when your immigration case isn't approved, isn't denied, and simply stops moving? If you've been waiting months or even longer with no meaningful update from USCIS, there may finally be some good news. A recent federal court decision challenged several USCIS policies that had placed certain immigration benefit requests on hold. And while that doesn't automatically approve anyone's case, it could help many stalled applications begin moving again. I'm Tapias, CEO and immigration attorney at Loigica. And today, I'll explain what happened, what it means, and what your options may be if your case is still stuck. What happened? In June 2026, a federal court in Rhode Island decided the case of Dorcas International Institute versus USCIS. The court held that several USCIS internal policies used to suspend or delay immigration benefit adjudications were unlawful and vacated those policies. USCIS has publicly acknowledged the ruling, stating that although it disagrees with the decision, it is currently complying with the court order while additional litigation continues. So at least for now, those hold policies are no longer in effect. What does that mean for you? This does not mean every delayed case will suddenly be approved. It does not mean security screens has disappeared. It does not mean that applications previously delayed because of those policies should no longer remain on hold for that reason. If your adjustment of status, employment authorization document, naturalization application, employment petition, investor petition, or another immigration benefit has been sitting without meaningful action, this ruling could be very significant. What should you do? So, what should you do if your case is still pending? First, determine why your case is delayed. Not every delay has the same cause. Some cases are waiting on background checks. Others involve requests for evidence. And some may have been affected by the policies discussed in the Dorcas case. If your case appears to have been caught in one of these administrative holds, you may want to request the USCIS resume adjudication in light of the court's rulings. When does a writ of mandamus make sense? Let's talk about a legal tool many people have heard about, the writ of mandamus. A mandamus lawsuit does not ask a judge to approve your immigration case. It also asks a federal judge to require the government to make a decision. For some applicants experiencing unreasonable delays, that can be a very effective strategy, but it is not appropriate for every case. Before filing litigation, an attorney should carefully evaluate why the case has been delayed and whether options remain available. In the right circumstances, however, federal litigation can be a powerful way to move a long pending case toward a decision. The most important lesson from the Dorcas decision is this: immigration delays are not always permanent. If your case has been sitting for months without explanation, don't assume you simply have to keep waiting. There may be legal options available. If you believe your case has been unreasonably delayed, our litigation team at Loigica can help evaluate whether your matter may benefit from additional advocacy or, when appropriate, a writ of mandamus. And remember, every U.S. immigration story begins with one of three ingredients: love, talent, or money. I'm Tapias, and I'll see you on the next video.